All right, hi everyone. It's 12:01 right now. Welcome to the webinar. We're just going to give a couple of minutes to allow any folks who are just a touch late to join us, and we'll get started in just a couple minutes. So please hang tight and I suppose awkwardly watch us do nothing on the screens. People are coming in pretty quick now. I think we're at a number where we don't need to wait. So I think we should go ahead and get started. Welcome again, everyone. My name is Christine DeWitt. I'm the Director of Client Relations here at Reynolds Mirth, and I'll just be facilitating the session today. Also, a hello from Glenn Tate from the Law Society, who couldn't join us today. I'm just going to go over a few housekeeping items and introduce the speakers before we get started and get into the good stuff. So we're scheduled to go for 60 minutes. If you need to leave us early, no problem at all. You will be able to view this webinar on demand anytime after the initial webcast by using the same link that you used to join today. So that link will basically just remain alive forever, and you can see the recording using that. At the bottom of your screen, you're going to see a number of small icons. These are various tools that you can use. This part of the spiel is a lot easier now than it was 2 years ago. Some of the tools are maximized on your screen already. Of course, the PowerPoint presentation should be front and center. You're seeing us in the speaker window at the top left. Below that is the Q&A tool. Please use the Q&A tool to submit your questions, and only this tool. There is a chat, which you'll see at the bottom. It's the one labeled chat, but we typically don't monitor those for questions, so please stick to the Q&A tool. The plan is to answer questions throughout the session, though we may, depending on how we're getting through the material, we may leave some for the end. At the right of your screen is a box that says download your materials, and you can find a copy of the slides from the presentation today, so please feel free to download those and keep them. And below the materials, you'll see your speakers' bios. And speaking of the speakers, today you're going to be hearing from Fred Kozak and Tess Layton. They're both partners in our firm and have extensive experience practicing in the area of defamation. I will not take up too much of their time telling you about their bios, but please do feel free to click through and learn more about them. One quick note, there's a very slim chance that we might lose Tess during this session, that she might have to leave us early just due to something urgent. If that happens, even though the chances are slim, I just wanted to let you know so that you're not surprised if it does. I think you're going to get a lot of value out of the session today, and with that, I'll pass it over to Fred to get us started. Fred.
Thanks, Christine. Hello, everybody, and thank you for this invitation. If Tess does have to leave us early, I'm going to have to make things up about her slides because I haven't really looked at them too closely. But I'm going to start with a warning. The warning is the law of defamation is an odd mix of things, and the quote that you see up on the screen was written in 1906. And it described a kind of a messy area of litigation then, which has only gotten worse in the last 115 years or so. Two things have amplified the mischief described in that quote. The first is that unlike the United Kingdom, where much of our law comes from, no jurisdiction in Canada has entered into a legislative defamation reform to address some of the anomalies that have arisen in the last 200 years. And the second amplification comes from recent or relatively recent advances in technology, where it's hard to reconcile some of the principles you're expected to apply in defamation cases with the internet and the ability to communicate to mass audiences over and over and over again. So we're going to try to hit on some of those things. Just as a heads up, here are the topics that we'll be dealing with. I'm going to be dealing with the first of those three, causes of action, presumptions, and defenses. Tess will deal with damages and emerging issues in internet defamation. So, cause of action. Relatively recent case from your court confirming that a plaintiff essentially has to prove on a balance of probabilities 3 essential aspects: publication, identification, and defamatory meaning. In this case, Justice Shaner awarded the plaintiff $50,000 in general damages, a pretty significant amount given the fact that this was defamation through an altered image of a cartoon that was distributed, causing the plaintiff some significant difficulties. Of special interest, though, is the fact that the $50,000 that was awarded in this case was in part aggravated by the post-publication conduct of the defendant. And Justice Shaner also noted that there wasn't an apology, which contributed to the somewhat significant damage award. Publication, pretty straightforward. It's important for you to know that publication is always given a very wide meaning in defamation cases. So whether you intended to publish it or not is not important. If it was communicated to even one other person, that's publication. That is communication to one other person other than the plaintiff. Sometimes people get into trouble because in writing a kind of a poison pen letter to the plaintiff, they will send a CC to a third party, or they'll send a CC to somebody not connected to the events. And that constitutes publication for the purpose of defamation. Publication, as you all know, can be oral or written. Both are considered to be defamation. No differences really in the ultimate outcome there. But it can also be a tweet or a posting on Facebook or a blog posting. Identification, again, pretty straightforward. Obviously, if you identify somebody by name, that constitutes identification under the Defamation Act. But you can also do it by including an image. You can do it by referring to somebody's title without actually naming them. And in some instances, you can identify a plaintiff by referring to a small group. Small group, given different meanings in different jurisdictions, but for example, if you were saying one of the members of a hearing tribunal was motivated by malice, even if you haven't identified that person by name, if it's a group of three, chances are any of the three could sue you for defamation. Defamatory meaning, well, there are a variety of ways of describing what is defamatory. Some of them you'll see up on the slide screen. I always suggest this: if you're trying to decide whether something is defamatory, the test that I try to use is I substitute my name for the name of the potential plaintiff, and I try to ask myself, do I think that people who know me and saw this statement about me would think less of me? And if the answer is yes, or if it causes people to shun or avoid me or be embarrassed by being around me, then it's probably defamatory. So you can have straightforward defamatory statements, or you can have implied defamatory meanings, and you can also have defamation by innuendo. Implied defamatory meaning, simple example might be three true statements. John Smith had his warehouse burned to the ground last night. Recently, he increased his insurance coverage. Fire investigators suspect arson. Three very simple statements, all easily demonstrated to be true, but the implied defamatory meaning is, and would be understood to be, he torched his building to take the benefit of the increased insurance proceeds. Once elements are proven, once the three elements are proven on a balance of probabilities, there are two very important presumptions that arise. The first is defamatory statements are presumed to be false. which sounds pretty straightforward, except that it then means that if the defendant is hoping to rely on the defense of justification or truth, he or she will have the onus of demonstrating that the defamatory statement is false, which is sometimes easier said than done. And secondly, a presumption that a defamatory statement will lead to general damages. So all people, even those with criminal records, are presumed to have a reputation worth protecting. And even without proving that the defamatory statement had a bad impact on you, general damages will be presumed, and you're entitled to the benefit of that presumption. Notice provisions are really important in defamation cases, and with the advent of internet and archived publication information, it's gotten a lot more complicated. So under your Defamation Act, Section 15 says that if you're suing a newspaper or a broadcaster, you have to first provide notice of your intention to sue that entity. And that notice must be given within 3 months of the date of the publication or broadcast. And the notice has to be personally served. So without taking that step, you're statute barred from proceeding to a lawsuit. Second limitation period to be aware of, Section 16 says that you have to commence your action within 6 months of the date of the publication or broadcast or the defamation. And a kind of a footnote, a kind of an odd anomaly in your legislation. Under 16.2, if you do sue within the 6 months, you can actually resurrect a statute-barred claim if the earlier publication occurred within 1 year of the date that you commence your action. Now, the date of publication has become very muddied because of the internet. And some or all of you may be aware of what's called the single publication rule or the multiple publication rule. Again, a vestige of what I will call centuries-old law. In fact, it dates back to 1849, a case where the Duke of Brunswick was very upset about a defamatory statement made about him in a local newspaper. But he was pretty indecisive, and he stewed about it. In fact, he stewed about it for 17 years. And when he finally decided to take action, somebody told him that he had missed the limitation period. So what he did was he sent his servant to the local library, asked for a copy of that newspaper, which they had archived, read about the Duke of Windsor, and he used that to form the basis of resurrecting his cause of action. That was a part of the law in Commonwealth countries for the next 150 years. The United Kingdom has done away with it, as has the United States of America, but we still have vestiges of that. And so the issue comes up if something bad is published about me on the internet, when is the date of publication, or does it resurrect each and every day that somebody can access that? And the answer is we're not sure anymore because there are conflicting cases which Tess will talk about. But it's enough to know that you've got Section 15 and 16 issues when it comes to notice of your intention to take action on behalf of a client. I'm going to quickly go through the defenses. So again, remembering our framework, if a plaintiff proves that a defamatory statement has been made about her and it's been published and she's been identified, proves those things on a balance of probabilities, it's then up to the defendant to establish on a balance of probabilities one of the defenses, the first of which is truth or justification. So truth or justification pretty straightforward. You have to prove all of the elements of the defamatory statement are true. And as I said, because defamatory statements are presumed to be false, that can be an onerous burden. Sometimes a defendant will plead a lesser defamatory meaning. So in a story about somebody being charged with a criminal offense, the plaintiff will often take the position that the defamatory meaning is that he committed the offense. And the defendant will plead, no, I didn't say that. I said you were charged with an offense, and I intend to prove that you were charged with the offense. I won't be able to prove that you were convicted of it. So that would be trying to prove a lesser defamatory meaning that the defendant claims was intended. Absolute privilege, that arises and protects people in what I will call sanctioned forums, where courts recognize the importance of protecting people in the House of Commons or in the Senate or in the legislature. The statements that they make within those protected forums are protected by an absolute privilege, which means if an MP in the House of Commons says something, even if it's defamatory and it was malicious, they can't be sued because the defense of absolute privilege would apply. You should bear in mind that people who are reporting on those forums, that is, if you're a reporter covering those comments, or if you're a reporter covering a public meeting or a gathering or a hearing tribunal proceeding, that's partially protected. It's protected by a qualified privilege. So the qualified privilege is limited, meaning if it's a fair and accurate report and it's made without malice, that privilege would apply, but malice will defeat a qualified privilege.
If I could just jump in, Fred, I just have a comment about qualified privilege that might sort of pique your interest. Sometimes we see an issue that litigants have with respect to whether or not statements in court documents or pleadings are covered by privilege, and in fact they are. So often in family law cases or other contentious matters where there are sort of defamatory statements made in pleadings, that's covered by a privilege. And in some cases it can be defeated by malice, but it's often difficult to base a claim off of a defamatory statement in pleadings. And another thing that Fred mentioned earlier that I think is helpful to sort of resurrect here is the concept of a letter that Fred talked about. If you're writing a letter and it has defamatory comments and you send it to one person but CC a bunch of other people, we can sometimes run into privilege concerns there where, for example, someone has a concern about a nurse administering doses to patients that are above the recommended doses and sends a letter to her employer commenting on those concerns, but decides to CC the minister, a bunch of doctors, some other nurses, and perhaps the professional regulatory body. So that's an example where a qualified privilege can be exceeded. And so you might have had a qualified privilege to tell your boss, but you don't have a qualified privilege to sort of spread that around to a bunch of different people. So those are my only comments, Fred. Sorry to interrupt.
Yeah, no, that's a great example. And qualified privilege has often traditionally been referred to in an analysis of, did you have a duty to report it? And so just to follow Tess's example, let's say a client came to you and said, I want you to take over a file. I had another lawyer pursuing this claim on my behalf, but I'm not happy with him. And in fact, I think that they might have misappropriated trust money that I had given because I'm told that it's no longer available, but I didn't authorize it being used for anything. So in looking at that, you might come to the conclusion that you have a duty to report that lawyer to the Law Society. And you might also conclude that you have a duty to report that lawyer to the managing partner of the firm. But if in doing so, you send a copy of your letter, for example, to someone else who may be considering using that lawyer to pursue a claim, the qualified privilege that you have in bringing that information to the attention of a regulatory authority would be exceeded, and you could be sued by the person for that statement. So thanks, Tess. That's a helpful example. I know I'm hurrying through these defenses, but many of these are fairly straightforward, and I'd be happy to answer any questions. So the next defense, fair comment. I don't like the name. It should no longer be known as the fair comment defense. I think it should just be labeled opinion or comment. And it protects a speaker's right to express an opinion or a comment about some aspect of life. And so if you think of a restaurant review or a movie review, or some other opinion you express, as long as what you say is clearly identified or recognized to be comment or opinion, and as long as your opinion is based on provable facts, and if it's on a matter of public interest, then the defense should prevail. And so a few years ago, the Supreme Court of Canada decided a case called Wick Broadcasting, and they made it very clear that the comment doesn't have to be fair. In fact, the comment can be outrageous or outlandish as long as it's an opinion held by one or more people based on provable facts. That should sustain the defense. The difficulty with the defense often is separating what is comment or opinion from what is fact. Responsible communication, relatively recent adoption of a defense that first arose in the United Kingdom, principally used by investigative journalists, where they have an important public interest story, and some aspect of that public interest story either can't be proved, or there are some inaccuracies in the facts that are serious allegations, but which can't be proven. As long as a reporter can prove that they were responsible and I would say not negligent in gathering those facts, the responsible journalism defense can prevail. And either an offshoot of the responsible communication defense or a separate defense, the jury's still out on that, neutral reportage. So essentially, if you're a reporter or you're commenting on a controversy, if you fairly cover both sides, let's say there's a dispute between two members of the legislature from opposite parties, and they're going back and forth at each other about an issue of public interest. Merely reporting on that and doing it in a balanced way won't get you into trouble as long as the reporting is neutral. And that takes us to the end of the defenses. So generally speaking, if you're relying on any of the defenses other than absolute privilege or truth, at the end of the defendant's case, it's open for the plaintiff to then rebut the defense by establishing express malice. And we'll return to express malice if time permits at the end. The only other thing I'll say before turning things over to Tess is because of all of the vestiges of defamation actions, which date back a couple of centuries now, it's one of the few actions where what you say in pleadings can exacerbate damages. And the conduct of the litigation can also have an impact on the damages awarded. The questions you ask during the discovery process can have an impact on the damages awarded. So it's something that you have to think about right from the beginning, whether you feel confident that you're going to establish truth is important, because if you plead justification or truth and fail to establish it, that can be used to increase the measure of damages, because courts have said pleading justification is essentially repeating the defamatory statement in your pleadings and in the lawsuit itself. Over to you, Tess.
Thanks, Fred. That's a really good couple of comments about damages, because we're going to talk about a case, McDonald & Co., which is a decision by Justice Shaner, which talks about the factors in assessing general damages. And she also talked about all of the different heads of damages that we can see in a defamation action. So general damages, special, aggravated, and punitive. So this case involved a plaintiff, McDonald. She was the COO of an organization after having been involved in that organization for 10 or so years. A group of former employees of the organization sent a fairly damning letter accusing her of bullying, harassment, and some other serious allegations of workplace misconduct. So the defendants didn't defend the claim in this case, so we don't have the benefit of the other side's perspective. They were noted in default, and the plaintiff applied for judgment. The plaintiff claimed a very high damages number, which was $100,000 for general damages, special damages for lost past and future earnings, because she was not actually given the permanent COO position. She was dismissed and demoted after the letter. So that was in the amount of roughly $61,000. Also claimed for aggravated damages in the amount of $50,000 and punitive damages in the amount of $25,000. So Justice Shaner agreed with the plaintiff, awarded $100,000 in general damages, which is a very high number. But she considered the 6 factors set out in Hill and Church of Scientology, which is a decision by the Supreme Court. And in that case, as Fred alluded to, it talks about the number of different things that can be considered in assessing damages in a defamation action. And some are those that you might not expect. So those are, number 1, the plaintiff's conduct, position, and standing. Number 2, the nature of the defamation. Number 3, the mode and extent of the publication. 3, the absence or refusal to retract or apologize. 5, the conduct of the defendant, and that includes conduct in the litigation, and as Fred mentioned, conduct in pleadings and in discovery. And 6, the evidence in aggravation or mitigation of damages after the defamatory statements were made and through the course of litigation. So in this case, Justice Shaner held that the damage to the plaintiff's reputation was significant. The letter was widely disseminated, not only to the board of directors of the organization, and this goes back to what I was talking about earlier, where you can claim a qualified privilege if you have a duty to report something, but once you go beyond that duty, the qualified privilege fails because you've exceeded the occasion. So here the letter was sent to the media, a couple of ministers, a number of different individuals, and some other current and former employees. So there was also never an apology, despite the fact that one was requested a number of times. And there was also an independent third-party investigation by her workplace into her conduct, and she was cleared of all wrongdoing, but unfortunately that report never became public, so it didn't repair her reputation at all. The court found here that the defendant's litigation conduct, given the fact that they didn't participate or defend, was not a significant factor, but given the severity of all of the other factors, $100,000, which is a fairly high number, was awarded. With respect to special damages, the court found that while it wasn't certain that the plaintiff would be ultimately promoted to the permanent COO position, she had advanced in the company and was paid the maximum allowable bonus every year. So on a balance of probabilities, she should be assumed to have been promoted to that role, and therefore her special damages award should be commensurate with the difference from her old position or COO position to the position that she was demoted to after the letter. In this case, the court declined to award aggravated and punitive damages, essentially saying that the conduct here doesn't rise to that sort of egregious and high-handed level that's required to sustain an award of aggravated and punitive damages. One other thing about your Defamation Act, there's a couple of funny things about it, but your Defamation Act deals with the limitation on awarding only special damages, so no general damages, in certain circumstances. So that's set out in Section 19 of the Defamation Act, which says that the plaintiff shall only recover special damages if it appears at the trial that the defamatory material was published in good faith, it was on a matter of public interest or for the public benefit, it didn't say that the plaintiff had committed a criminal offense, and it was essentially a mistake or a misapprehension of the facts, and a full and fair retraction and apology was issued. So in those cases, and it can be defeated in some circumstances, but in those cases, only special damages will be awarded and not general damages. So Fred mentioned as well that new developments in internet defamation have really created a wrinkle in what publication means, and not just what publication means. We'll talk about jurisdiction, but the internet, despite the fact that it's been around for 30 years, has really turned the tort of defamation on its head. It used to be really easy to determine when something was published in a newspaper or sent to somebody in hard copy. But when we talk about the internet and the fact that things sort of exist in perpetuity online, we don't have an easy answer. And so as Fred mentioned, the Duke of Brunswick case, I won't bore you with the facts again of that case, but that sort of initiated this concept of a multiple publication rule. So that means every single time something is read or accessed by a third party, the limitation period is restarted, because effectively a new cause of action is occasioned each and every single time it's read. So as Fred mentioned, this was abolished in the UK with the 2013 Defamation Act. So of course, it's actually built into the legislation now that there is a single publication rule in the UK. That's in respect of all publications, internet or otherwise. But in Canada, the issue is very, very unsettled. So the question now becomes, if something is posted online and remains there in the same place, what effect does that have on the limitation period, and what effect does that have on the cause of action? So that's really can be broken down into two issues. Number one, does a new cause of action arise each and every day, which resets the limitations clock? And number two, the discoverability aspect there. So should the discoverability principle apply so that when the article was first posted or when the plaintiff first knew about its existence, that's when the limitation period begins to run. So we have a couple of cases that we'll talk about here. The first is ARC Society and CBC. That was a 2019 decision by the Alberta Court of Appeal. The facts of that case are actually very specific, and it was the product of essentially, at that point, 11 years of litigation. So I won't get into the facts, other than to say the issue arose from a Fifth Estate broadcast, which was broadcast on national television, but was also placed online on the Fifth Estate webpage. So in, obviously, online format, it stayed there until 2017. In 2017, it was removed from the website, but it was inadvertently reposted about 6 months later back into the same place that it had been, and it was exactly the same broadcast that it had been before. When this happened, the plaintiff immediately sent a defamation notice based upon the reposting and applied to amend its first claim that it had sued over 8 years before and the litigation was ongoing, to add a host of defamatory meanings. I think it was an additional 70 paragraphs, essentially widening and expanding its claim significantly, essentially on the basis that the republication had resurrected the limitations period and therefore started a new cause of action. So the Chamber's judge ruled that the amendments were time barred and did not allow the amendment based upon the internet posting. But at the Court of Appeal was split. And there's actually 3 decisions that come out of that, written by each of the 3 justices. And so that was Justice Wakeling, Justice Pentelechuk, and Justice McDonald. Justice Wakeling said, every day material remains on a website, a potential new cause of action arises. Effectively, because the 2017 reposting happened, despite the fact that it was in the same place, it wouldn't have mattered. Essentially, every single day something is online, a new cause of action resurrects. So Wakeling essentially endorses the old multiple publication rule from the Duke of Brunswick case that Fred mentioned. Justice McDonald said, well, on the flip side, there are strong sort of public policy reasons to reject that idea. It would be inappropriate to apply the law differently online as it would to print publications or television publications. But in any event, the 2017 reposting wasn't a republication because it was posted in the same place and would have reached the same audience because it would have also reached an internet audience. So this is sort of the line of reasoning in the US, where the US has made a single publication rule based upon the fact that if you publish something in the same medium, so on television, and then later publish it again, it reaches the same audience. So he followed an American approach. Justice Pentelechuk decided to not decide on the issue. So instead she said, well, I prefer to deal with this issue at trial, but I agree the amendments can be allowed. So, that gives a little bit more weight to Justice Wakeling's reasons because, of course, the majority allowed the amendments. So that's the state of the law in Alberta, which is confused, frankly. On the flip side of things, the law in PEI by the PEI Court of Appeal is very different. So the case of Enyama and the Saltwire Network from 2020, so this actually came out a couple of months after the ARC decision. In that case, the Guardian newspaper published 2 articles in May of 2016 about a court decision about the plaintiff who was deemed vexatious litigant. The Guardian was later bought by the Saltwire Network, and essentially everything that was on the Guardian platform migrated to the Saltwire platform. And Enyama sued right after that happened and said essentially that because it was migrated to a new platform, it was republished, and therefore the limitations period reset. The Chambers judge rejected that argument, and the Court of Appeal did as well. So the Court of Appeal essentially said, well, the Wakeling decision from ARC was really just one judge on a 3-judge panel, and it would be illogical, like McDonald said, to apply this rule differently to other broadcasts and other sort of newspaper and print mediums than to the internet medium. So different standards for websites and broadcast or newspaper don't work, and a plaintiff could essentially lie in wait for years before suing, so they're going to adopt the single publication rule. So the single publication rule is also consistent with the law in Ontario, which is essentially that the single publication rule applies to the discoverability principle as well. So it goes a little bit farther. So if a plaintiff knew or ought to have known with reasonable due diligence of the existence of defamatory content online, the limitation clock starts to run from that time. So it sort of puts the onus on a plaintiff if they hear about or know about defamatory statements being made about them, that they have to actually seek it out on the internet. So hopefully Alberta will fall in line eventually, but right now the law is a little bit of a jumbled mess. So jurisdiction is another area where we really see the internet complicate what the rules are and what the law is, because once something is posted online, it's really published to the World Wide Web, and generally speaking, accessible anywhere. There are issues that arise with geo-blocking of certain websites in certain countries not being able to access things. But essentially, when we're talking about a country like Canada, where we can essentially access anything that's published anywhere, we have those issues. So there's 2 cases that we'll talk about. One is a Supreme Court of Canada case, and that is Haaretz and Goldhar. So Haaretz and Goldhar is a case where Goldhar sued Haaretz. Goldhar owned a football club in Israel, but he lived in Canada. He had quite a reputation in Israel and some reputation in Canada. Israel-based Haaretz made an application to strike the statement of claim on the basis that the court did not have jurisdiction over the alleged defamatory article. And the Supreme Court of Canada applied a two-step jurisdiction analysis. The first step talks about jurisdiction simpliciter. So essentially whether or not there's a real and substantial connection between the lawsuit and the jurisdiction. So the lawsuit and Canada, the plaintiff has that onus to establish that there is a presumptive connecting factor. So the court looks at things like the defendant's residence, where the defendant carries on business, where the tort was committed in the province. And if there's a presumptive factor, the defendant then can rebut that presumption by showing that the presumptive connecting factor doesn't actually show any real relationship. It only shows a weak relationship between the subject matter and the forum. So really the real and substantial connection test is more objective. The second part of the analysis, which is the forum non-conveniens, is more of a case-by-case approach to say, well, look, this jurisdiction might be better, but is there another one that is even better? So the court's holding in Haaretz on the first step was that jurisdiction simpliciter was made out. The tort was essentially committed in Ontario when the article was accessed or downloaded and read by a third party, because we know from the three-part defamation test that Fred talked about, as soon as somebody reads that defamation has occurred. So Israel in this case was actually the more convenient forum, though, after the forum non-conveniens analysis, and that's because the comparative convenience and expense for the parties and the witnesses favored Israel, and essentially the thrust of the damage to his reputation was in Israel because Goldhar owned a football club there, he had many businesses in Israel, and his reputation was really much bigger issue in Israel than it would have been in Canada. So we'll contrast that with Justra and Twitter. The facts are very different in that case, but the court also gives some analysis about both the jurisdiction simpliciter and the forum non-conveniens test. Similar situation, it was an application to strike a claim brought by Mr. Justra. Mr. Justra is a prominent sort of Vancouver-based businessman who has a reputation in Vancouver and throughout Canada, but he also has some business interests in California. So Justra sued Twitter for various defamatory tweets that sort of arise from the 2016 American election. Because of his relationship with the Clinton family, he was implicated in a number of conspiracy theories like Pizzagate, and wanted to sue over those tweets. So the BC Supreme Court conducted the jurisdiction analysis on the application to strike. Jurisdiction simpliciter was presumed because there was evidence that there's over 500,000 users in BC, that tweets were read by at least some people in BC, and that Mr. Justra has a well-established reputation in BC. Twitter then tried to rebut the presumption on the jurisdiction simpliciter test by saying that, Twitter can't be expected to defend the defamation claims wherever users are located, because that would be very onerous. Tweets are published all around the world. And they also said, while Justra's main reputation is outside Canada, instead it's in California. So the court actually looked at the tweets and said, well, the subject matter of the tweets are not only related to the American reputation, but they're also related to his Canadian reputation. They talked about his residence in Vancouver. There were some other Canadian characteristics about those tweets. So the court found there was jurisdiction simpliciter. On the forum non-conveniens branch of the analysis, the court found, well, this is a very important analysis in defamation cases, because one forum the tort may have happened there, but another forum may be more appropriate. In that case, the law in California, the fact that he had some presence in California, and the fact that there would be some witnesses located in California was not enough to find that California would clearly be a better jurisdiction. So, of course, the trial judge is not bound by these findings, and this may still be a live issue at trial. The case is also under appeal. It'll be a long time before these issues are sorted out, but that's the way that the BC BC Supreme Court has landed for now on jurisdiction. So in terms of final thoughts, I mean, there's not only a wide range in law in Canada with respect to some of these issues, but there's also a wide range in how the law is applied in other Commonwealth jurisdictions and also in our neighbor's country, the United States. So the US has some safe harbor provisions which protect those big social media giants like Twitter and Facebook. Essentially, they're considered platforms and not publishers. And so legislation in the United States, which is the Communications Decency Act, actually builds in this protection for these web giants so that content posted by a third-party user is not something that those platforms become liable for. So Section 230 provides that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So that's a really wordy way of saying they're platforms and they're not publishers. We contrast that with the UK Defamation Act, which does have some protection for websites who don't actually create and post that content. Essentially, in the UK, if an operator can show that it was not the poster of the website, there will be no liability. But that defense is defeated if the plaintiff can't identify who it was who posted the content online, if the claimant, so if the plaintiff gave the website notice of the fact that there was defamatory content posted online, and if the website failed to respond. Now, that's similar to the current state of our law in Canada. A case in BC establishes that a website, upon receipt of notice that a defamatory content is posted on its website, essentially becomes a publisher and must act very promptly in taking it down. And in that case, 1 or 2 days was sufficient to actually take down the content and avoid liability. Now, there's a recent development in that the US rule might actually be adopted in Canada, but we're not sure how that's playing out. It's because Section 230 of the Communications Decency Act was adopted by Canada as part of the USMCA. That's the United States Mexico-Canada agreement, which is the new NAFTA. This would significantly amend the common law, but because it's so new and the USMCA was just, I think, ratified in July of 2020, there's been no judicial commentary on the implications of that USMCA. We talked about the UK Defamation Act and the single publication rule already, so I won't cover that again. Something that you may be interested in is litigation strategy in terms of unmasking anonymous posters. This is an issue that we see all the time, and frankly, the practical reality of this is that it's incredibly costly and very time-consuming to identify somebody who has posted anonymously online, and it's difficult to sue unless you know or have a really good idea of who that person is. So it's easier when we're dealing with posts on Facebook and Twitter where people are using their own names. But when we get into websites like The Dirty, various Crime Stopper groups, it's really difficult to find out the identities of those people. So the process here, I'll just go over it briefly in case anyone has come across this issue, is that you'll have to apply to a court here to get a declaration that's what's posted is defamatory or contrary to Canadian law. Then you'll have to take that order, apply to the United States through an agent to compel the website to actually disclose the IP address of the poster and any other information about the poster. Once you have the IP address, you have to go back to court here and have the internet service provider, so in Alberta that would be Shaw or TELUS, disclose the identity or owner of that IP address. And Shaw and TELUS only keep this information for 6 months, so you have to do it quickly, and of course you have to retain a US agent, so it gets quite pricey. It's much better if you know or have a very good idea of who the poster is, because you can sue and get that information through the discovery process. So on a final topic, we're running out of time. We'll talk about something new that has come out in the last couple of weeks, which is the online harms bill. An emerging issue around the world is regulating content that's posted on social media platforms and how we can address some of the hate speech and misinformation, fake news, and really extreme forms of online defamation that are published on those platforms. There's been a lot of talk and response worldwide about this. Some places have done nothing, but most countries are talking about it. The UK has a regulatory process that they are in the process of enacting. Germany already has legislation. And so the online harms bill is Canada's response. So the online harms bill targets 5 kinds of content online, which is child sexual exploitation, terrorism, inciting violence, hate speech, and non-consensual sharing of intimate content. And the bill proposes to have a regulator essentially step in to regulate speech and be able to audit social media platforms about how they're going about their content moderation, whether or not they're doing it properly. There's monetary penalties for non-compliance and certain timelines that they have to respond to complaints by, and timelines for appeals, and basically sets out how they're supposed to moderate their content rather than leaving it to the social media platforms to moderate it themselves. There's been some, I would say, strong concerns about overbreadth and potential regulation of free expression. Surprisingly, both the CPC and the NDP has said that the legislation should be halted, at least temporarily, until some of those issues have been worked out. And the other issue is that the CRTC is going to step in as the regulator. So there's concerns about whether or not the Canadian radio and television regulator is the appropriate sort of body to do that. So that's all I have for you on the online harms bill, and that brings us to the end of our presentation. Thanks for sitting through it, and I'm just going to pass it back to Christine, who's going to conclude for us.
Great, thanks, Tess.
Christine, sorry.
Oh, yeah, go ahead, Fred.
Sorry, one thing that I just wanted to comment on, something that Tess mentioned, and that is the impact of an apology on damages. So it's common sense that if somebody makes a defamatory statement and they immediately apologize for it, that should have a significant mitigating impact on the damages award. But the thing to note is an apology is essentially an admission that the statement was defamatory. So once the apology is made, you likely lose any ability to defend using any of the defenses. The sole question remaining is the quantum of damages. So that's an issue that comes up quickly in any alleged defamation case, and it's something that you have to make a decision on pretty promptly. That was the only comment. Thanks.
Great, thanks. We still have a couple of minutes, so if anyone has any questions, please feel free to throw them in the Q&A while I just go over our last small bits of housekeeping. There are really only 2 things. The first is, just as a reminder, you can use this link to view this webinar on demand anytime in the future. It will stay up there, and you can also use it to download a copy of the slides if you haven't done so already. So those are the 2 reminders. And that's it. I don't see any questions coming through. Tess and Fred, I typically do a last call to see if you have anything else to add, but I think that we're probably good. If you have any questions, please feel free to reach out to us. And other than that, thanks for joining us. Have a great day.
Thanks, everyone.
Thank you.